of Common Cause v. Union of India, 2018, the Supreme Court's Constitution Bench had already ruled in the Giancor case that the right to a dignified death was a constitutionally guaranteed right. Additionally, the court made it clear that the Giancor ruling did not convey the idea of passive euthanasia. Furthermore, the court highlighted the difference between different types of euthanasia, primarily active and passive euthanasia. It is stated that where active euthanasia necessitates an overt action to terminate the life of the individual, while passive euthanasia involves the act of removing life support to end the suffering of the individual. It concluded that the court's decision in Aruna Shanbag to rule that passive euthanasia could only be legalized through legislation was incorrect. Concerning living wills, the court determined that there was clear evidence of the adoption of the idea of advance medical directives in India. The court went on to say that the ability to carry out an advance medical directive was a move towards safeguarding the rights to individual autonomy and self-determination. A standpoint which showcases the best interests of the patient may be used in cases when patients are unable to make an educated choice, permitting a caretaker to intervene and decide the alternative on their behalf. This case went into great detail about the relationship between autonomy and liberty and the right to privacy, as it was outlined in the case of Justice K.S. Puttaswamy v. Union of India. In this case, the court cited passages from various judgments. The court even explored the relationship between privacy rights and their consequences for euthanasia. In addition to Indian cases, the court also referred to international court rulings. The court cited the decision in Re Quinlan, 1976, in which the New Jersey Supreme Court determined that, as the person's condition deteriorates, the interest of the state changes substantially, and the person's right to privacy with regard to their personal integrity grows greater. A guardian, including family members, spouses, or children, might do this on behalf of the patient if they are unable to exercise their rights to privacy independently. The ruling rendered by the European Court of Human Rights, ECHR, in the case of Pretty v. the United Kingdom, 2002, was also cited in this judgment. In this matter, the European Court of Human Rights came to the conclusion that a person had the option to prevent what they perceived to be an unpleasant and traumatic end to his or her life. In addition, the court ruled that such a decision would be protected by the right to respect for private life, as outlined in Article 8, Sart 1 of the European Convention on Human Rights. The court stated that the right to privacy mandated preserving the moral fortitude of decisions made by the individual in the private sphere of choices pertaining to death. The court held that the safeguarding of these fundamental rights was an extension of the right to privacy, as they were connected to the fundamental